dive into a pretty wild, human-centered legal drama. It's based on a landmark 2026 Supreme Court case, Sumit Bansal versus MGI Developers. Our mission today, for you listening, is to really figure out exactly what happens when multiple guarantee checks bounce for the exact same debt.
Yeah, it's a fascinating one. I mean, it sounds like an absolute nightmare scenario, right?
Entirely.
But it raises these incredible questions about how the law balances the rights of a creditor against the rights of the accused when a real estate deal just goes completely south.
So let's unpack this story, because it starts in a way that is just incredibly relatable. Imagine you are the buyer. You're this guy, Sumit. You pay a massive 1.72 crore rupees upfront for some commercial properties.
A huge amount of money.
Right. But the deadline comes and, it goes. Endless delays. No property at all. So the builder, Manoj Goyal, agrees to refund you the principal plus a 35 lakh rupee compensation.
Okay, so how does he try to pay him back?
He issues 2 checks from his company bank account.
But importantly, he doesn't actually stop there, does he?
No, he doesn't. As a personal guarantee, the builder also issues 2 additional checks. And these are from his personal joint bank account for the exact same amounts.
Got it. So 2 separate sets of checks.
Exactly. First, Sumit tries to cash those personal guarantee checks, and they bounce. The bank's remark is literally just, exceeds arrangement.
Ouch.
Yeah. Furious, right? So a little over a week later, he tries the company checks.
Let me guess.
Yep. Those bounce too. This time the jargon is funds insufficient.
Which, despite the different banking jargon, both legally trigger Section 138 of the Negotiable Instruments Act.
Right, the bounce check law. So Sumit weaponizes both sets of checks. He files multiple criminal complaints against the builder.
And that brings us right to the core conflict of the sources we're looking at today. If we slow down and look at this from the accused builder's perspective,
he is suddenly facing multiple separate criminal cases for the exact same underlying real estate debt.
Precisely. The question becomes, can an accused claim it is illegal parallel prosecution to be tried multiple times for one single debt?
I mean, it is a highly relatable struggle for anyone trying to recover their hard-earned money. But at the same time, we have the fundamental right not to be harassed by the legal system.
It's tricky.
Doesn't the builder kind of have a point, though? It feels fundamentally unfair to face double the criminal charges for a single 1.72 crore debt.
It feels a bit like giving someone the keys to 2 different cars to settle one debt and being shocked when they drive both away.
That is exactly it. Why wouldn't the courts agree with him?
Well, we know Section 138 strictly criminalizes bounce checks. But the real fiction here is how Section 139 interacts with it.
Okay. Break down Section 139 for us.
Section 139 creates this incredibly powerful legal presumption in favor of the payee. In this case, Sumit.
So the law automatically assumes the debt is legally valid.
Right. It shifts the burden entirely onto the accused builder to prove otherwise. And importantly, he has to do that during a full trial.
Ah, okay. So when the builder tries to use Section 482 of the Criminal Procedure Code.
Yes, to get the High Court to quash or cancel the cases early.
He's basically asking the High Court to completely ignore Section 139's presumption of guilt. He wants a shortcut out of the trial.
Exactly. He claimed he shouldn't face a multiplicity of proceedings for one single debt. He even argued he had already paid some of the money back.
But the Supreme Court stepped in, and they had very firm reasoning on this.
Very firm. They ruled that high courts absolutely cannot conduct early mini-trials to resolve disputed facts.
Because at that early stage, the High Court lacks the witnesses. They lack the evidence needed to verify if a debt was actually paid.
Or if one set of checks was simply meant to substitute the other. That strict boundary is the entire point of the ruling.
So whether the checks were substitutes or just additional guarantees.
Those are facts to be argued in a full trial, not decided prematurely to get a case thrown out.
Multiplicity proceedings is a trial defense, not an excuse to skip the trial altogether. Looking at the fallout of this ruling, if I am a business owner taking a guaranteed check today, this changes my entire strategy. The Supreme Court definitively ruled that every single bounced check creates a separate legal violation.
A distinct cause of action, even if they all stem from the exact same real estate deal.
Which is exactly why everyday citizens need to be careful. For those of you listening, never return alternative guarantee checks prematurely.
Multiple checks equate to multiple liabilities until the money is actually sitting in your bank account.
And for any legal professionals listening, if your client bounces multiple distinct instruments presented on different dates, pleading a multiplicity of proceedings, defense is going to fail.
High courts simply cannot short-circuit the trial process to protect defaulters.
It is a massive win for creditors. But if we connect this to the bigger picture, it leaves us with a critical question to consider.
Oh, for sure. If every single bounced check creates a distinct criminal liability, does this strict interpretation simply make doing business safer?
Or could it give creditors unchecked power to weaponize the legal system, launching endless criminal cases over a single unpaid debt?
Definitely something for you to ponder next time you write or accept a guarantee check.
Thanks for joining us on this deep dive.